Dear friends, yesterday we covered 10 2-mark questions in administrative law. Today we bring you another exciting set of 10 2-mark questions. Let's tune in carefully to this podcast so learning becomes easier, faster, and more enjoyable. Stay focused and make your study truly effortless. The next question will further strengthen your basics. What are the three main organs of state? In administrative law, the three main organs of the state are: the first one, legislature, the lawmaking body responsible for framing statutes and policies that guide administration. It enacts laws under constitutional authority. The second one, executive, the organ responsible for implementing and enforcing laws. It includes the president, prime minister, ministers, and administrative machinery. The third one is judiciary, the system of courts that interprets laws, ensures their proper application, and reviews administrative actions for legality, fairness, and constitutionality. Let's take the next question and see what the answer is. Nemo Debet Esse Judex in Propria Causa. Nemo Debet Esse Judex in Propria Causa is a fundamental natural justice principle, meaning no one should be a judge in their own case. It ensures impartiality, fairness, and absence of bias in judicial and administrative proceedings. Bias can be personal, which is explained in Mineral Development Corporation versus State of Bihar. Bias can also be pecuniary, which is explained in DIMS versus Grand Junction Canal. Bias can also be subject matter, which is explained in A.K. Kripak versus Union of India. It can also be departmental, which is explained in SARFU versus President of South Africa. Or bias can also be preconceived, which is explained in Porter versus McGill. Exceptions include the doctrine of necessity, Ashok Kumar Yadav versus Haryana, statutory exemption, Sharan Lal Sahu versus Union of India, or waiver. Its application safeguards justice and public confidence. Here is another interesting question to sharpen your understanding. 2 reasons for establishment of public corporation. The first one, provision of essential services. Public corporations are established to deliver crucial public services such as utilities, transportation, and healthcare, which the private sector may not adequately provide. This ensures accessibility, affordability, and quality for the general population. The second one, promotion of economic development. They facilitate investment in vital industries and infrastructure requiring large capital or offering low profitability but significant national importance. Public corporations also regulate natural monopolies, safeguard public interest, and create employment opportunities, contributing to overall economic growth. The upcoming question is a common one in exams. What is contingent legislation? Contingent or conditional legislation is a type of delegated legislation where the legislature enacts a complete law, but its operation depends on the fulfillment of specified conditions or events. Here, the legislature retains full policy control and the executive's role is limited to determining when or where the law becomes effective without creating or altering the law itself. The law only comes into force once the conditions precedent are satisfied, such as the occurrence of a particular event or decision by an administrative authority. Unlike general delegated legislation, contingent legislation delegates only the timing or application, not lawmaking power. Now friends, listen carefully to this 2-mark question. 2 distinctions between quasi-judicial and administrative functions. First one, procedural rigor. Quasi-judicial functions follow formal procedures similar to courts, including holding hearings, collecting evidence, and adhering to principles of natural justice with decisions based on objective facts. In contrast, administrative functions are guided by policy and expediency, often made without formal hearings or evidence, relying on the authority's discretion. Second one, basis of decision making. Quasi-judicial decisions require objective satisfaction, meaning they are grounded in established standards and facts. Administrative decisions, however, depend on subjective satisfaction, allowing flexibility to achieve policy goals without strict procedural constraints. We shall continue with the next short question in sequence. What is a non-sovereign function? In administrative law, a non-sovereign function refers to duties or activities performed by the government or its authorities that are similar to those of a private individual or organization rather than in the exercise of the sovereign powers of the state. These functions do not involve enforcement of law, regulation, or public authority. Instead, they are related to private or commercial activities. Let's take up the following question and understand it briefly. What is writ of prohibition? In administrative law, a writ of prohibition is a judicial order issued by a higher court to a lower court, tribunal, or quasi-judicial authority, restraining it from exceeding its jurisdiction or acting contrary to law. It is preventive remedy issued before a wrongful act is done to ensure that the authority does not proceed illegally. Now we move to the next important short question. What is prohibitory injunction? A prohibitory injunction is a judicial order that restrains a person or authority from doing a specific act. It is a preventive remedy aimed at stopping an act that may cause harm or violate someone's rights rather than requiring someone to perform an act. Here comes another brief question you should never miss. Define information as per Right to Information Act. Under the Right to Information Act 2005, information is defined in Section 2F as information means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. Finally, let's address the following 2-mark question together. 2 requisites of government contract. 2 key requisites of a valid government contract under Article 299 of the Constitution of India are: the first one, written and expressed in the name of the authority. The contract must be in writing and clearly stated to be made by the President for Union Government or Governor for State Government. This ensures clarity about the authority on whose behalf the contract is entered. Second one, executed by an authorized person. The contract must be signed by a person authorized by the President or Governor, usually through a notification in the official gazette. Failure to meet these requisites renders the contract unenforceable and the unauthorized executor may be personally liable. Dear friends, that's all for today. Tomorrow we'll share the final set of 2-mark questions in administrative law, so stay tuned. Meanwhile, develop a healthy habit. Go for a morning or evening jog. While walking or jogging, listen to this podcast and make your study easier, productive, and enjoyable. Combine fitness and learning and turn your routine into a fun, healthy, and effective way to master administrative law.